Okay, here we go. All right, so good afternoon, everyone. Thank you so much. Every Tuesdays at 3 p.m., we have our contract class. Today, we're going to be talking about the transfer disclosure statements and laws regarding exemptions. So typically, when you represent a client that has a single duplex, triplex, or a fourplex, they must complete what is called a TPS, but known as a transfer disclosure statement. And the whole purpose of the transfer disclosure statement is to provide the consumer, the buyer, with any known disclosures regarding the property. Okay. Any known disclosures regarding the property, any issues, defects, modifications, anything in all that will ultimately be a concern to the buyer. That's the reason for the disclosure, is to provide the buyer with peace of mind that what the seller is selling is something that the buyer is okay with. Now, with that being said, remember that the buyer also has their time period to do their due diligence, and more so to do any and all inspections regarding the property, right? They can get a roof inspection, plumbing inspection, electrical inspection, foundation inspection. Um, let's see, AC inspection, fireplace, pool, spa inspections, right? Jacuzzi inspections, sprinkler systems too can be inspected, right? Um, what else? What else? Floors, water pressure. I mean, anything and everything usually is a generalized inspection, but the buyer has 17 days to do these inspections and ultimately decide if they're going to moving forward with the process of purchasing, or ask for a request of repairs, a credit, or a price reduction, or the buyer decides, you know what, after all the inspections we've done, we just don't feel comfortable with the condition of the property, and therefore the buyer has the right to exercise paragraph 14B and cancel escrow. Okay. So let's dive deep into what is the TDS requirements, right? The TDS law applies to transfers, including options and lease options too. Okay, so if you're dealing with an option or a lease option, and basically what a lease option means is in the future, right? A tenant has the option to purchase the property in a year from now, 2 years from now, then they also fall under the requirements that the seller must provide a transfer disclosure statement, okay, of any real property or any residential stocks, improves with the four or fewer dwellings, meaning a 4 unit, a triplex, duplex, and a single family. And this also includes manufactured homes, condos, townhomes as well, okay? The TDS law does not apply to residential properties of 5 or more units, commercial, industrial, vacant land, or agricultural property. So what that means is if you have a potential deal, or you're working with a buyer that has interest in submitting an offer on anything more than 4 units, then it's exempt. You don't need to get a copy of a TDS. You can't force the seller to provide you with the TDS. Or on the flip side, if you are the listing agent and you're selling a 5 unit or more, then you don't have to provide the transfer disclosure statement. If the property is a commercial, you don't have to provide a TDS. If it's industrial, you don't have to provide a TDS. If it's raw land, vacant land, or agricultural properties, again, you do not have to provide a TDS. Now, with this being said again, what if a property is there and the house burned? You cannot live in the property, but the house is semi-burned. 50% of the house is burned and 50% of the house is still intact. Do you still need to provide a TDS on a property that is burned, cannot live in it, but it's going to eventually be torn down, right? Torn down to build a new construction. So what's your take? What's your thoughts on a property that is not where you can live on, but it is a property that was an existing single family residence, and unfortunately during a fire, you cannot live in it. Does the listing agent and the seller need to provide a transfer disclosure statement? How many say yes? Okay. How many say no? And then how many don't know? So the answer to that, it really depends, right? So the answer is yes, you must still provide a TDS, because what transpired with that house? Something happened, right? A fire. So that's a known material fact. So even though you cannot live in the property and you know that that house is going to be torn down and it's going to be raw land, you still need to provide a transfer disclosure statement. Okay. Because the seller, the buyer needs to know what transpired that fire, right? Was it a forest fire that ultimately started? Was it an electrical fire? Was it an accidental fire? Was it a computer that blew up? Who knows, right? But yes, to answer your question, is in that specific circumstance and scenario, you must provide a transfer disclosure. Okay. I hope that kind of clears that answer. Yes, sir.
Something like that about 15 years ago. I got a special price. You have to go between the seller and me, or through the bank to.
That's right.
So they keep track of.
Yeah. So, and this is where you have to do a little bit of research, right? Because if you're buying a piece of land, what type of zoning is it? Is it residential, R1, R2, R3, R4, right? Or was it raw land? There was never any type of construction done. This is where you have to do a little bit of legwork and investigation to determine, what type of property you're dealing with. All right. So what are the exemptions to the law requiring sellers to provide the TDS? So here it is, folks. California law exempts the following types of transactions from the TDS, meaning to be obligated for the seller to complete the transfer disclosure statement. Transfers require a public report pursuant to 11018.1 of the Business and Professional Code, and transfer pursuant to 11010.8 of the Business and Professional Code, where no public report is required. Transfers pursuant to court order, such as a court order, probate sale, sale by a bankruptcy trustee, writ of execution, eminent domain, and transfer resulting from a decrease from specific performance, transfers by foreclosures, including deed in lieu of foreclosure, and a transfer by a beneficiary who has acquired the property by foreclosure or deed in lieu of foreclosure, transfers by a fiduciary in the course of the administration of a deceased estate, guardianship, and conservatorship, or a trust. Okay, so these are by the specific of the Business and Professional Code, which if you can Google 11018.1, it defines, and then also 11010.8, it tells you from the professional business and professional code that these are the exemptions that allows the seller or this entity not to provide a TDS or TDS, transfer disclosure statement. Okay. And I want to repeat what these requirement is. Okay. A court order or probate, right? What is a probate? When someone passes away, doesn't have a will, a trust, and ultimately now it goes to the court to decide who is going to be the executor to the trust to facilitate the sale. Well, they're exempt. So if they get the authorization from the court to allow the property to be sold, then they are exempt from providing a TDS. One, they probably don't know anything about the property. They didn't live in the property, right? And typically it's someone like a third party, a family member, friend or a colleague or someone that was administrating the initial process of the probate. And it's unfortunate, but it happens quite often where a lot of homeowners don't have a will or a living trust. So you just got to understand that they are exempt. If the property falls in a bankruptcy, right, the bankruptcy court system says that, we're going to end up selling your property so that way we can pay off all of your obligations and debt, then the bankruptcy court system is exempt from providing a transfer disclosure. One, they don't know anything about the property. They're just selling the asset to pay off the obligations that the consumer had of debt. Okay, so they're also exempt from providing a TDS. A writ of execution or eminent domain. Let's say that the state of California, the city of Torrance, the county of Los Angeles decides that they want to use the benefit of the land to expand for the growth of the community, the growth of population, and it happens to be your property. Well, anything that is in regards to an official eminent domain by the state, the county, the city, or local organization that is taking possession of someone's property for the benefit of the community, then it falls under an eminent domain. An eminent domain then allows the exemption from providing a TDS. A deed in lieu of foreclosure, a specific performance. So if there's a situation of a decrease of specific performance, let's say that buyer and seller were in escrow. Seller passes away during escrow. And they're at the home stretch of this process. There were, let's just say, a week from closing, but the seller passed away, did not have a will or trust, but they're still in escrow. The buyer and the family members of the deceased now can, expedite the process through the court system to do a probate. But because there's a property in escrow, they can accelerate the process by specific performance. If the property falls under specific performance, then they're exempt from providing a TDS to the buyer. Now, if the party, the seller, did the TDS prior to their passing away, then they fall under the category that they complied with it. But this is, again, if they did not, and now you're providing disclosures, they would be exempt from providing a transfer disclosure. Transfer by beneficiary. So if you are the successor to a trust, right? Now the sellers had a living trust or a will, and they name you as the successor to that trust, and something happens to the seller, and now you're in charge of the execution of this trust, and you decide that part of the instructions of the seller's request was to sell the property, then you're in charge of that, then you would be exempt from providing a TDS. Okay, you do not have to fill out a TDS because you're the successor of the trust. Now, the successor can be anyone. It can also be family members and children. Now, it's a little gray area when it comes to like children, because the children obviously know the ins and outs of the property, but because it falls under the category of the 1101.8 of the Business and Professional Code, guess what? They also would be considered exempt from providing the TDS. Even though they may know the history, maybe they grew up in the property as a child, as a teenager, as a young adult, and they come and visit the parents, quite often they know the ins and outs of the property. They still would fall under the exemption. They do not have to provide a TDS. Okay, they would be protected under that class. Okay, the other is obviously foreclosure or deed in lieu of foreclosure. So basically, if the property becomes a foreclosure, or if the seller gives back the property to the bank, then the bank is obviously exempt from providing a transfer disclosure. The transfer by fiduciary in the course of the administration of the deceased estate, such as a guardianship and conservatorship, or a trust will also again fall under exemption. So they do not have to complete a transfer disclosure statement. Okay, any questions on that? All right, that's right. Yeah. One, they don't know any history about the property. This is why they'll put and put the pressure back on the buyer, that the buyer do as many inspections on the property, which the buyer has, by default, 17 days to do so.
But if he didn't know it, and then the bank checks, they can agree, or he gets the buyer to buy it and they can adjust the price.
Yeah, which has nothing to do with disclosures. You're talking different things about price, terms, and condition. I'm only talking about the exemption of the transfer disclosure. All right, so continuing on the transfer disclosure statement law exemptions, note as an exemption to this exemption occurs when the property is held in a revocable trust, and the trustee is a natural person who is solely trustee of the trust, as well as the former owner of the property or an occupant in possession of the property within the year preceding the transfer. Okay. Transfer from one co-owner to one or more other co-owners. Transfer made to a spouse or to a child, a grandchild, parent, grandparent, or any other direct ancestor or descendants. Transfers between spouses and connections with a dissolution of marriage or similar proceedings. Transfer by the state controller pursuant to the unclaimed property law. Transfers as a result of failure to pay property taxes. Transfer or exchanges to or from any government entity. Leases, regardless of duration, within the exemption of the lease, within an option to purchase, or a ground lease compelled with the improvements. Okay, so basically what this stipulates is that if you're going to transfer your property to someone that's a co-owner, right? Let's say it's a husband and wife, brother and sister, sister and sister, brother, nephew, whatever the case may be, right? If it's within the guidelines of these parameters, right, it has to be a co-owner or a spouse or a child, okay, grandchild, or what is it, parents or grandparents, then ultimately they're exempt from providing a TDS. Okay, they do not have to provide a TDS. One, they're probably know about the property, so they're exempt from doing any exemptions because they're going to be living in the property per se. Okay. Boom. That is it. This is the quickest contract class that I have. But before I do so, I wanted to also provide with a sample of the contract itself. So let me let's see here why that's showing. All right. Okay. So this is what the real estate transfer disclosure statement looks like. Under the California Civil Code 1102, it
There's
defines.
nothing showing, Simon. We don't see anything.
You don't? Okay,
Nope.
my apologies. Let me see what I mean, I see it over here on my end. But let's see, maybe if I do this. Okay. Now do you see it?
Yes, thank you.
Okay. Sorry about that. Thanks for letting me know, because on my screen over here on the training room it does show. Okay, so this is the official real estate transfer disclosure statement, California Civil Code 1102. This is the most current TDS, which was revised in June of 2023. Where do you know that it's been revised? That was right here. Form TDS revised June 2023. That can change come December 2023. They may add, take away, modify this form. But for the time being, this is the most current transfer disclosure statement. It is a 3-page documentation and is the most vital part of a process of real estate, of real estate transactions. This is what gets a lot of buyers and sellers into disputes and potential litigations and lawsuits because of not disclosing things that the seller knows about the property and not letting the buyer know, hey, by the way, there's this issue, there's that issue. This is the reason you want to provide a one second. This is the reason you wanted to provide the transfer disclosure, so that way the buyer knows exactly what they're getting themselves into, right? And this is just one of many other disclosures that you'll receive. So I'm just going to go through the motion. I'm not going to go detail by detail, but it goes through the disclaimer. This statement is a disclosure of the condition of the above described property in compliance with 1102 of the Civil Code. As of date, it is not a warranty of any kind by the seller or any agent representing any principal in the transaction, and it's not a substitute for any inspections or warranties the principal may wish to obtain. So basically what it's saying is that, hey, Mr. and Mrs. Buyer, you know, we are providing you with anything that we know about the property, and, you know, the property is going to be sold in as is condition. Mr. and Mrs. Buyer, you have every right to do your due diligence and inspections regarding the overall condition and to satisfy yourself regarding the property to either move forward with the sale, request a repair, or decide to cancel. And any of those three is perfectly fine based on the purchase agreement. This allows the buyer and the seller to either move forward, negotiate terms, or decide to cancel mutually. And then, you know, the seller then will go in a different direction. Okay. So the real estate transfer disclosure statement is made pursuant to the 1102 of the Civil Code. Other statutory requirements, disclosures depending upon the details of the particular real estate transaction, special study, zoning, and purchase money liens on the residential property, and then the substitute disclosures, the following disclosures, and all other disclosures required by law, including the NHD, the natural hazard disclosure report statements that may include airport nuisance, earthquake, fire, flood, or special assessment. So basically what it's saying, that the buyer is aware that there is additional disclosures that may pertain to the specific area or specific on the property. It may be near an airport, it may be near a school, it may be near a park, it may be near industrial, it may be near a very busy location, right? That there's a lot of traffic. So these are, again, aspects of what you know, the seller must provide to the buyer, so the buyer can make a sound decision if they're going to continue moving forward or not. Okay. Seller's information is pretty self-explanatory. The following are representations made by the seller and are not the representation of the agent. If any of the information is disclosed and it's not intended to be part of any contract between the buyer and the seller. So here, remember one thing, folks, page 1 and page 2 of the purchase agreement, okay, of the transfer disclosure must be done by the seller. We as real estate agents do not do anything in this part. If they ask you to fill it out, you say no. That is not my obligation and my responsibility. This is done by the seller. The reason I say this is because if there's ever a lawsuit, the first thing courts are going to say, the judge is going to say, the attorney is going to say, you, Mr. Seller, 1, do you occupy the property? Yes or no? Seller is or is not occupying the property, right? Then the subject property has the items checked below, right? Here are the items that the seller is indicating that the property has. Does it have an oven? Does it have a microwave? Does it have a dishwasher? So you're gonna check, not you, the seller's gonna check all of the items that pertain to this property, okay? This is all the seller is doing, okay? This is not the agent filling it out, not assisting, not helping. And if they don't understand, because maybe language, they don't understand English, then they need to find someone else to help them guide them. Because again, as soon as someone puts the ink on this, they're the ones that are acknowledging that whatever they're putting on this disclosure is true to its fact. Okay. Page 2 goes into, Mr. Seller, are you aware of any significant defects or manufacturers in the following, right? You're going to say yes or no. The question here and it's very broad, but I also want you to understand as a licensed agent, you want to guide your client to the best of your ability to explain the importance of this disclosure, because this is what most attorneys in a court systems use to deflect, dispute, or ultimately go after for damages because of known material disclosures that were never provided. And it'll go into the list of items such as ceilings, interior floors, walls, insulation roofs, windows, so on and so forth. Then it goes into section C. Are you, seller, aware of any of the following, right? Here is where the seller will decide if it does pertain, then they're going to say, yes, it does. Or if it doesn't pertain, they are going to say no to it. At the very end, if anything that they've answered as a yes, they must explain that in details. You can also attach an additional sheet if necessary, so that way you can provide any additional disclosures. Section D basically talks about 1 and 2. The seller certifies that the property as of close of escrow will be in compliance with the health and safety code by having smoke detectors, which are approved, listed, and installed in accordance with the state fire marshal. These are regulations that ultimately must be provided. Now, where I get this question quite often is, well, Simon, if they're going to tear down the house, if they're going to renovate the house, does the seller have to still comply with this code? And the answer is yes. Yes, they do. You as the agent need to provide that guidance to the seller, saying, as part of the process is that the seller is certifying, right? Because they're initialing the section 2 of the TDS. That at close of escrow, that we will be in compliance with the health and safety code by having, operating smoke detectors. Now, it's a gray area and it's also a fine line, because I've seen where there's exemptions on this because they're going to tear down the entire house. Why would we spend money to hardwire a smoke detector when the house is going to come down? But we got to use common sense, right? If you know that, document it, put it in writing that you did comply. The property was going to be tear down, and the new owner will then put the hardwired smoke detectors when the house gets built. There you at least have that you complied with that requirement, that ultimately the house was not going to be lived in, and it was going to be torn down as soon as we close escrow. Soon after close of escrow, the house was going to come down. Then you at least can go back and say, oh, okay, this is what transpired, this makes sense, then you should be okay. Okay, yes, sir.
And then comes under what if? If you close escrow, you gotta get in.
Yeah.
And it burned.
Mhm.
It's gotta be covered.
That's right. So again, you gotta look at what the requirements are, and these are the requirements. Part 2 talks about the health and safety code of the water heater, tank, and brace. Well, what if it's a tankless water heater, right? Well, typically it is anchored to the wall, and then you would be in compliance. And again, let's say that it's a tear down house, that nothing is working, right? Property is being sold in as is condition. Well, you're going to note that, you're going to disclose that, and you're going to document it. So that way, if this ever comes back, you at least have records of what transpired, and now you have proof of what ended up happening. Part three, and we'll finish with this, is the agent's inspection disclosure. This is where both the buyer's agent and the seller's agent will undergo and sign based on their above inquiry of the seller as to the condition of the property, and based on the reasonable, competent, and diligent visual inspection of the following accessible areas. And it's talking about accessible, right? It's not telling you to move furniture. It's not telling you to crawl in any crawl space. It's not telling you to go up in the attic. It's just a visual inspection, okay, of the accessible areas, all right? Accessible areas of the property in conjunction with the increase stated in the following, right? And then here, there's three things. See the attached agent visual inspection, better known as the AVID. Agent notes no items for disclosure, or agent notes the following items. Now, from my personal experience, you do not want to check off section 2, okay? Find something to put, okay? Because it makes you look like you're competent and you've done your homework. If an agent just says, agent does not find anything to disclose, it tells me you didn't look deep into it, right? Then when something does happen is, well, Simon, didn't you see that big crack on the living room? Wasn't that a big indicator for you to, ask a little bit questions or put that as an observation on your AVID, right? Common sense, folks. Put something. Do not check that, and never say that there is nothing to disclose. Find something, okay? Not saying to crack a window, but I'm saying, there's always going to be some defects, some issues with the property. Identify, and it's always visual, right? You're not going to be moving furniture. And then you have line items here where if you want to write them down, or if you want to just attach, which part of the requirement is the AVID as well. Agent will sign, okay. The buyer's agent and the listing agent will sign, okay. And then section 3 of the TDS 1102.3 of the Civil Code provides a buyer with the right to rescind a purchase contract for at least 3 days after delivery of the disclosure, if delivery occurs after signing off of the offer to purchase. And if you wish to rescind the contract, you must act within the prescribed period. A real estate broker is qualified to advise on real estate. If you desire legal advice, consult your attorney, okay? So what this section talks about is basically, let's just say that the seller provides you with the transfer disclosure, and later we find out after the buyer has released contingencies of physical inspection, there's a leak. And the seller says to the listing agent, hey, Simon, just want to let you know, we just found out that there's a leak. We're going to take care of it. But I want to warn you that that was something that we just found out. So immediately you got to let the buyer agent know, and the buyer has 5 additional days to do any due diligence and inspections, get estimates, and ultimately within that 5 days, even after they release the physical inspection contingency, they might have the right to cancel this and back out and retain their full deposit, okay? Because this is something that they were not anticipating or expecting, right? And most of the times the sellers want to do the right thing. They want to get it completed. We just need to make sure that the information is related to the buyer's agent and the buyer, and that usually will squash it. But there's those instances where maybe the seller says, look, I'm just providing you what transpired. We're not going to do anything. The buyer is going to have to take care of that. Then the buyer has the option within 5 days to get inspections, estimates, and then in that time, either decide to move forward or decide to cancel escrow. Okay, even though they release a physical inspection. Okay. Any questions regarding the TDS? No questions? All right, team. Well, that concludes our class for today. I know we're little less than we typically do. Usually try to spend about an hour. This one was more gears to that one specific of the transfer disclosures we talked about. the exemptions, right? Who is exempt, who is not exempt. Now, here's another one that I'll throw and then I'll finalize it with that. And I hear this quite often. What if the property is in a trust? And the first thing I always ask the agent is the seller still alive? The answer is yeah, they're still alive. Okay, but it's in a trust. And based on what I'm hearing on the TDS, if it's in a trust, then they're exempt. They're not exempt, folks. They're still alive. They still live in the property. So that doesn't necessarily mean they are exempt from or waiving the TDS. Okay, they still must complete a TDS. Okay, so I'll leave that as a reminder. So any other thoughts, questions? Cool. All right. Well, that concludes our team meeting. Excuse me, our contract class. If you have any additional questions, please don't hesitate to reach out to me. I'm here to help you navigate these contracts. Thank you, everyone.
I have